So good day. So this is the case of Civil Aviation Authority of the Philippines Employees Union versus Civil Aviation Authority. The facts of the case. The petitioner claims that the sale authority orders and memoranda were issued and implemented by respondents in clear violation of the 1987 Constitution and RA's protection for the security of tenure CAAP staff since they jeopardize their employment, the Republic Act number 6656, and claims that the true intention of RA number 9497 only reorganized the agency, not completely abolished it. But the law omitted any reference to the employment status of the staff of the disbanded ATO. In a similar vein, the petitioner claims that the law was broadened and modified by the IRR and that this court's interpretation of the law was interfered with by the legislature when it issued the aforementioned resolutions. And the holdover status granted to the current employees of the ATO broke the law, putting them in a precarious position and robbing them of their security of tenure. So the issue here is whether the ATO was abolished under RA number 9497. Number 2, whether the incumbent ATO employees' constitutional right to security of tenure was impaired. Number 3, whether there was a grave abuse of discretion when Section 60 of the IRR provided a holdover status for ATO employees, which was not expressly provided for under RA number 9497. So the ruling of the court, number 1, no. The law that states that the only legislature has the authority to abolish a public office is established in this region. This follows from the legal tenet that states that the ability to create also includes the ability to destroy. A public office may be established by the Constitution, a statute, or another legal provision. The same legislature that established the office may therefore abolish it, with the exemption of cases when it was established by the Constitution itself. Number 2, no, it is important to note that the court's opinion in kapisanan ng mga kawani ng Energy Regulatory Board versus Bahrain, which said that an order of abolition must not only be issued by an authorized body but also in good faith. When abolition is carried out in good faith, it does not violate the public service workers' constitutional right to security of tenure or is not carried out for political or personal gain. An office may be abolished for financial reasons, to eliminate duplication of duties, or in response to a clear and explicit constitutional requirement for such termination of employment. A legal nullity results when one office is abolished and replaced with one that has identical responsibilities. The incumbent is regarded as having a never stop holding office while there is a void abolition. According to the petitioner, if an office is abolished and then reinstated under a different name, it cannot have the effect of dismissing the officer holding it. However, the court did not find that the ATO's elimination was done in bad faith because it was not merely reinstated under the CAAP. The Republic of the Philippines must fully subscribe to the allowed capital stock of CAAP, an autonomous regulatory agency with quasi-judicial and quasi-legislative functions and corporate features. Its approved capital stock is 50 billion pesos. It is merely joined to the DOTC to facilitate policy cooperation, while the Director General is in charge of using all of the CAAP rights and carrying out all of its obligations, including managing all of the organization's employees and activities. The Board of Directors is in charge of the latter's corporate powers, and it has the complete financial freedom to support its operations. And number 3, no, A petition for prohibition will succeed only in the case of egregious abuse of discretion. Simple discretionary misuse is insufficient. It must be serious. Grave abuse of discretion is described as the arbitrary and capricious use of judgment that is so obvious and severe that practically amounts to a refusal to carry out a legal obligation, such as when the power is used in an oppressive and arbitrary manner out of hatred or anger. And the second case is about Giusamar Inc. versus Department of Transportation and Communications and Civil Aviation Authority of the Philippines, GR number 217158. The facts of the case: the Department of Transportation and Communication, the DOTC, and its attached agency, the Civil Aviation Authority of the Philippines, CAAP, issued an invitation to pre-qualify and bid, or the invitation, in 2014 for the development, operation, and maintenance of the airports in Bacolod, Silay, Davao, Iloilo, Laguindingan, New Bohol, Panglao, and Puerto Princesa, the projects. According to the invitation, the projects will be awarded through competitive bidding. The DOTC and the CAAP released the instructions to prospective bidders, or the ITPB, which said that prospective bidders must pre-qualify and bid for the development, operation, and maintenance of the airports, which have now been grouped into two groups, bundled projects. According to the standard method for bidding on the bundled projects, prospective bidders may bid on only Bundle 1 or Bundle 2, or both Bundles 1 and 2. Invoking the issue's transcendental importance, Giusamar Inc. or Giusamar filed the current petition for prohibition before the Supreme Court, or the court, challenging the legitimacy of the project's bundling and seeking to restrain the DOTC and the CAAP from proceeding with the bidding. The issue here is, can the court take cognizance of the issues raised by Giusamar, taking into account the principle of transcendental importance? So, the ruling of the Supreme Court: no. According to the doctrine of the hierarchy of courts, requests for the issuing of exceptional writs against first-level courts shall be filed with the regional trial court, and petitions against second-level courts with the Court of Appeals. As an exception to the theory of judicial hierarchy, the court has permitted plaintiffs to seek direct relief from it on the grounds of serious and important reasons, which include, but are not limited to, matters of transcendental importance. However, the court underlined that the presence of one or more of the so-called special and important reasons is not the deciding factor in deciding whether to allow the invocation of its original jurisdiction over the issuance of exceptional writs in the first place. Rather, it was the nature of the question posed by the parties in those exemptions that allowed the court to grant the direct action. An examination of the cases in which the court used the transcendental importance of the constitutional issue raised to justify a violation of the principle of court hierarchy would show that resolution of factual issue was not required for the resolution of the constitutional issues. To be clear, the transcendental importance doctrine does not vest the court with the authority to address factual issues and act as a trial court. The only time that the court may hear a case in the first instance, despite the presence of factual issues, is when it is performing its constitutionally mandated task of reviewing the sufficiency of the factual basis of the President's proclamation of martial law under Section 18, Article 7 of the 1987 Constitution. In this instance, Gio's arguments summarize against the legitimacy of the project's bundling are intimately linked to underlying factual issues, the resolution of which necessitates the receipt of evidence. Because the court is not a fact finder, it cannot address these factual questions in the first instance. As a result, the court reiterates for the benefit of the bench and bar that when a question before it involves the determination of a factual issue essential to the resolution of a legal issue, It will refuse to resolve the question regardless of the allegation or invocation of compelling reasons, such as the case's transcendental or paramount importance. Such a question must first be presented to the appropriate trial courts or the Court of Appeals, both of which are specifically qualified to try and decide factual issues. And lastly, this is the case of Philippine Airlines versus Civil Aeronautics Board, Case Digest 270 SCRA 538. The facts of the case: Grand Air applied to the Civil Aeronautics Board for a Certificate of Public Convenience and Necessity or CAB. The Chief Hearing Officer issued a hearing notice instructing Grand Air to serve a copy of the application and notice on all scheduled Philippine domestic operators. Grand Air submitted its compliance and applied for a Temporary Operating Permit or TOP. Paul objected to the application, claiming that the CAB lacked jurisdiction to hear it until Grand Air had a franchise to operate from Congress. The Chief Hearing Officer denied the opposition, and the CAB approved the TOP for a 3-month period. Opposition to the TOP was also denied, and the CAB supported its assumption of jurisdiction over Grand Air's application by citing Republic Act 776, which grants it the express authority to issue any TOP or certificate of public convenience and necessity.